And now on BBC Radio 4, here's Clive Anderson with the programme which gets behind the legal issues of the day.
Hello and welcome to Unreliable Evidence. We live in a free country where the right to speak our mind is fundamental to our liberty and vital to our democracy. Developed under the common law, freedom of thought and expression are nowadays protected by the European Convention on Human Rights and recognised in other international declarations. In theory, then, we're entitled to say what we like, even if others don't like what we say. Well, in practice, there have always been plenty of restrictions on what may be uttered in public or published in print. Through the centuries, laws against blasphemy, libel, pornography and sedition have been deployed to keep private thoughts out of the public eye. Newspapers, theatrical performances, film and television have been subject to a variety of forms of censorship and control. But what of freedom of expression today? Do new laws designed to prevent hate speech and to protect individuals and minority groups from offence and victimisation have the effect, intended or otherwise, of inhibiting free speech? Is the criminal law the right weapon to use against those who are disrespectful of other races, religions or sexual practice? Is it necessary in the interest of public order to prosecute, for example, a demonstrator for telling the Prime Minister he has blood on his hands? Is it really grounds for arrest to suggest that a police horse is gay? In what circumstances is it against the law to use social media to make antisocial remarks? Is it really a policeman's lot to police which jokes are liable to cause offence? Is our wish to be tolerant of minorities making us intolerant of free speech? To express themselves freely on this subject, I'm joined by Ivan Hare, a barrister experienced in the field of civil liberties and human rights law, who has written extensively about hate speech and related matters. Professor Gavin Phillipson is a professor of law at the University of Durham and a qualified solicitor, with research interest in European and United Kingdom human rights law and freedom of expression. Neil Addison is a barrister who for 8 years was a senior Crown prosecutor. He's an expert in the law relating to harassment, bullying at work and discrimination. Among the books he has written is Religious Discrimination and Hatred Law. He joins us down the line from Liverpool. Andrew Trotter is the Chief Constable of the Transport Police. He plays an active role within the Association of Chief Police Officers, ACPO. Amongst other things, he chairs their Communications Advisory Group. So, what do we think? Is the principle of free speech a fundamental right that still exists, or is it a luxury which has to be compromised in the interest of public order? If I come to Professor Phillipson, first of all.
Right, I think it's undoubtedly a fundamental right, and I think it is quite strongly protected in the UK, but I think undoubtedly we have some overbroad laws that do constrain it too much and do leave it to police and prosecutors to draw lines that I don't think they should have to draw.
So what do you think from the police point of view, Andrew Trotter? Do you think it's a hard job for policemen to decide where these lines are breached? And this rather can be, I think we'll discover, it can be a fairly grey area of law.
I think it's a really difficult area. I mean, quite rightly, we're interested in protecting people, not just minorities, but people who take offence at other people's actions and behaviours. And quite frequently, we're there to try and deal with potential breaches of the peace that arise from people's actions and to protect people from what they see as harassment and bullying. And that's to be balanced against the right of free speech. So it's a tough call for the police.
So Ivan Hare, Rowan Atkinson, a comedian and actor, has described it as a creeping culture of censoriousness. And we're accepting a sort of criminalisation of speech that offends or insults or disparages. Is he onto something there, or is he just overreacting?
Well, there's no doubt that there's been an expansion in the groups that are protected from speech which might be regarded as inciting hatred against them. So we've had incitement to racial hatred on the statute book in different forms since the 1960s. But it wasn't until the 2000s that we added incitement to religious hatred, and since then we've added incitement to sexual orientation hatred too. And a lot of people argue that there's no principal basis for distinguishing between those grounds and a number of others, including disability or the other grounds upon which discrimination is prohibited generally.
I want to come back to all those points with you. I just want to see what Neil Addison thinks about this general point. I presume you agree that there is or there should be a general principle for free speech, but there are limits.
Well, certainly, since I was a lad, it's got a lot more difficult, I think, for people to express their views freely. I mean, when I was growing up, it used to be quite a common phrase, I can say what I like, it's a free country, and nobody really says that anymore. And going back to what Andrew Trotter was saying, you said that it was the job of the police to protect those who take offence. It's not the job of the police to protect those who take offence. It's the job of the police surely to protect those who are in danger, not to protect them from opinions that they disagree with or find offensive.
I just want to bring in Professor Phillipson again. What do you say about this point of principle point, that once you start saying, well, you don't hate speech related to racial matters, I think the argument then was, well, there are people who might be rude about somebody because they're Muslim. That's not strictly speaking a race, so it seemed odd not to protect that. And then things develop in a sort of patchwork way like that. Have we lost sight of a principle, or is there a principle there that we just can't identify at the moment?
No, I think we kept sight of the principle, because when the law was extended to cover religious groups and groups defined by sexual orientation, it was actually enacted in a way that was much, much narrower than the race hatred laws, because it was specifically recognised that religious belief, for one thing, is chosen rather than being innate, and also that religion needs to be subject to robust criticism in a democracy in a way that you can't really sensibly criticise someone's race. And there was this great hoo-ha from comedians and so on, they wouldn't be able to make religious jokes anymore. So in recognition of all the concern, there was a great deal of protection for free speech built into the religious hatred offence and the sexual orientation offence that wasn't there for the race hatred one. So in fact, it was a bit of those concerns actually didn't really turn into anything, because I think Ivan would agree that those offences are extremely hard to prosecute because they're so narrowly drafted and you have to prove so much. What's the real threat is these very broad public order offences.
Well, it is quite complicated law. You have to sort of look at Section 29J to see reasons why you might not prosecute somebody, because you are entitled, if I'm understanding this correctly, you are entitled to sort of ridicule or criticise religious beliefs, but not the people who hold them. You're nodding, Ivan, here. I'm hoping that means I've got that roughly right.
Yes, you have. And of course, Gavin's quite right as well to say that the law on incitement to religious hatred is narrower than the law on incitement to race hatred. And that's one example, that there is a free speech clause, which you've referred to, Clive, in relation to incitement to religious hatred and hatred on the grounds of someone's sexual orientation. But also it's narrower in that you have to use only threatening words. It's not enough to use abusive language or behaviour. And also that you have to intend thereby to stir up the relevant form of hatred. So there's no doubt that those offences are narrower. But the argument that they're coherent is a different one, because although you can say, of course, religion's different because you might choose your religion, most people wouldn't accept that it's appropriate to treat sexual orientation speech in the same way, because you arguably don't choose your sexual orientation. And a number of religious groups would say that actually they didn't choose their religious orientation either.
But you're arguing that those are sort of three categories, but you could add in all sorts of other things as well, which are fairly similar on grounds of whether you're male or female, whether you're disabled or not. And you could probably keep adding endless categories of things.
The origin of the offence of incitement to racial hatred was that it was contained in the first Race Relations Act. So that suggests that the motivation for it, at least in part, is to reduce the incidence of discrimination. And if you accept that that's part of the justification, then you might expect the law on incitement to mirror the law on discrimination. So it would cover, as you say, gender, and would certainly cover disability, and might be extended to other grounds too, as they're added to our list of prohibited grounds of discrimination in relation to employment or other matters.
But I suppose, I could ask this of Neil Addison in Liverpool, I suppose this is the way, the common law, the English law, the British way of doing things, is to see an abuse. There was racial discrimination, there were people being attacked for race in a way that perhaps relatively little of in these other categories. Is that the explanation for how we've got where we are? No?
Not at all. I mean, I would question the need for the racial hatred law. Leave aside the religious hatred or sexual orientation hatred law, because it is about behaviour or words that are likely to stir up racial hatred.
Yes.
Now, hatred is an emotion. It's not an action. Should the law be involved in words that deal with emotion? Different if you're inciting people to go out and hurt somebody because of their race or attack somebody because of their sexual orientation. Of course the law's got to stop that. That's incitement to action. But should it be involved in something that, at best, may incite an emotion?
What do you think, Professor Phil?
It's a common objection I've got in front of me, a quote that someone says, should the law be seeking to prevent someone from inciting a feeling? And it sounds a kind of strange thing for the law to do, but I think that's actually a misrepresentation of what the true target of the law should be. the philosopher Jeremy Waldron's written that he thinks that the purpose of race hatred laws is to ensure that everyone has a basic assurance of dignity before the law, of a basic kind of status simply as being a citizen who's accepted as having a basic equality, and that what hate speech does is trying to make certain groups feel particularly vulnerable, to feel they might be threatened, to feel that they might be discriminated against.
Yes.
And that really it's about providing that public assurance, and hate speech aims to destroy that, and it's nothing to do really with creating feelings in people.
I would say that actually the hatred law is designed for a purpose to prevent people expressing their opinions or their disagreement with government policies. And certain trends in society.
Okay.
Whether one agrees or disagrees with those, the danger is that the law is itself working as a censor, and the police then becomes the enforcers of the prevailing orthodoxy rather than keepers of the peace.
Well, this goes to the heart of what this discussion is about, of course. Is it a censorship measure? Is it stopping people from expressing themselves?
If it's someone who is ranting away about ethnic minorities or religious groups on a crowded tube station, yes, it is the role of the police to do something to protect people who are being attacked verbally and insulted. And those situations where there's likely to be an outcome potentially of violence, or even if there isn't, if you have a vulnerable person that's being berated for their ethnic origin or anything else, or their sexual orientation, then quite rightly I think people give up rights to the state and they expect protection from the state. This isn't just a dry academic subject. This is something which is real, that happens every day. And I think one of the great improvements we've seen in society is people are much more conscious of the sensitivities of others, and much more aware of it. There were no good old days years ago about when we could say what we felt like. What it meant was people got abuse all the time, be it on radio programmes, television programmes, in the street. We're a far more civilised society now, I think, because of a result of some of these measures.
Would that be not covered by, I think this is Section 5, but anyway, a general law about causing harassment, alarm or distress without having to specify it has to be to do with race or sexuality or anything else, just causing a breach of the peace, conduct like to cause a breach of the peace?
Well, yes, you can, but I mean, or public order under Section 5 of the Public Order Act,
Sure.
to some extent, or the other provisions of.
And as I understand it, Andrew, it would be regarded as an aggravating circumstance, wouldn't it, in relation to that public order offence, that you'd selected your victim by reference to their race or their sexual orientation?
Yes, I mean, and sometimes, of course, there are general rants. You might get crowds of people who are just chanting something, be they football fans, be they any other political group, and they may not have an immediate target around them, but because of the nature of what they're saying, the context of what they're saying, these things can cause real disturbance and real concern. And these things, still happen every day. And I think there is a role for the authorities to step in and protect those people who are being victimised.
Professor Phillipson?
I mean, I agree with much of what was just said from the police point of view, but I think we need to draw a distinction here, which is really fundamental to our discussion, which is between what you could call face-to-face words, face-to-face insults, what the Americans called fighting words, in other words, words that are likely to provoke a fight, or if not, at least words that are likely to make someone feel viscerally attacked, suddenly disturbed. They're just walking along in the street or they're getting on the tube, and suddenly, as you said, they get this tirade of abuse. Even the most ardent free speech advocates usually allows for some protection against those kind of what are sometimes called assaultive words. In other words, someone in your face screaming insults at you. Everyone, I think, agrees that there needs to be protection, because that's not really an attempt to engage in public debate. Where it gets controversial is where speech which is directed towards the public at large, for example, published in a blog or in a newspaper or something like that, is then prosecuted. And that's where the much more real free speech concerns arise, I think.
I'm sorry, yes, please, Neil Anderson.
Just on what Andy Trotter was saying, you didn't need the religious hatred law to stop somebody abusing somebody on transport or in the public area. That's always been illegal, going back centuries. If somebody is being personally assaulted, personally attacked, personally abused, the law has to deal with that. The racial hatred law is specifically dealing with separate situations, and what we're in danger of, that we got ourselves bogged down into a sort of hate crime arms race, where one group gets protected by more aggravated offences, then another group said, we're not protected, and then they're protected, and then another group, and it goes on, instead of really going back to the fundamental basis that the law should protect everyone equally.
I mean, I actually agree with you there. And then, there's no ambition on the part of the police, despite some of these rather infamous cases, for us to get involved in that side of the business at all. It's more than enough for us to be doing without doing those things. But I think, what I was really concerned about was the practical application of the things that we're talking about and how that affects people in everyday lives. And I do think there's something about setting quite exacting standards almost to say, look, we'd expect people to be tolerant of one another, to respect one another. It's certainly, when I look at internally within police forces, and I've been policing for many, many years now, many police forces, you look at, there's something around that this is the way we expect people to behave. And sometimes those sanctions against those who don't behave can be quite severe. But you see over time the culture change, the respect, the sensitivity to others change. And I think that's an important part of the way we've developed, I think, to a far more tolerant society than we were.
All right, Can I come back? I would disagree. I think we've actually become a far more intolerant society in terms of... I mean, just give me an example up in my area in the northwest, in Cumbria, nearby. There was a street preacher, Dale McAlpine. He goes there every week. He preaches, quoting from the Bible. Now, he was asked by somebody who was homosexual, what was he viewing homosexuality? He said, well, the Bible says homosexuality is a sin. That person then went and reported to the police, and the police arrested him for breach of Section 5.
Yes.
No, it is ridiculous.
This is Unreliable Evidence. I'm Clive Anderson. I'm discussing freedom of expression with Professor Gavin Phillipson, Barristers Ivan Hare and Neil Addison, and Chief Constable Andrew Trotter. Now, is the possibility here that the law is a bit too complicated and therefore quite hard to interpret? I'll give you an example of this. Harry Hammond, an evangelist, was arrested and charged under Section 5 of the Public Order Act because he displayed to people in Bournemouth a large sign bearing the words, Jesus gives peace, Jesus is alive, stop immorality, stop homosexuality, stop lesbianism, Jesus is Lord. In 2002, a magistrate convicted Hammond, fined him £300 and ordered him to pay costs. Now, we spoke earlier to Solicitor Simon Calvert from the Christian Institute.
We've a long chain of cases where Christian people expressing orthodox Christian views in perfectly moderate ways have found themselves on the wrong end of police investigations, arrests, and even prosecutions, simply for saying things that are unfashionable. They're certainly not hateful. They're certainly not inciting violence. We would never defend anybody seeking to incite violence. I spoke with an officer recently, and when I explained that my views that Parliament should not legalise same-sex marriage and that we were helping people to express this, she said, well, of course you're entitled to express that view, but of course equally, if someone comes and tells us that they feel offended then and they think it's a hate crime, we'll have to investigate. I mean, how can simply expressing your support for traditional marriage be a hate crime? But this officer, because of these ridiculous laws, somehow felt that she had to say something and that she might just have the power to shut me up simply for expressing that view.
That's reinforcing Neil Addison's point. But Professor Phillipson...
Well, if the law being referred to is the offence of inciting hatred on grounds of sexual orientation, of course, there would be a clear defence for the person under that law, because there's a defence to it which says that the discussion or criticism of sexual conduct or practices or the urging of persons to refrain from or modify their conduct or practices shall not be taken to be itself threatening or intended to stir up hatred. So in other words...
that defence didn't seem to operate in Bournemouth Magistrates' Court.
No, that was... The DPP and Hammond was charged under the Section 5, the much broader offence. So the point is, that's what I mean. These offences are actually specifically had defences written in. The specific hate speech offences had defences written in to protect, amongst other things, traditional Christian teaching. It's the public order laws that have been used against preachers. And I do find it baffling when the police investigate those cases.
Well, I suppose you'll have to answer on behalf of the police. All police in the country you're now representing.
Responsible for them all.
Yeah.
Now, I can't and don't defend some of the things and some of the examples that have been raised and others that we know of. I think there is something clearly about the way this is being interpreted. But I use a positive example from the DPP about his guidance on social media, where he's put out some very strong guidance about the high threshold before police should even start to look at these things. And I think that sort of approach, where we don't get involved in these issues unless it's absolutely a serious matter. And I am equally baffled by some of the examples that have been used.
Well, you're right. The DPP has, that's the Director of Public Prosecutions, has issued guidance on this. But there's a more general point, is there not, that under the European Convention, you're supposed to balance people's competing rights as to whether it's a proportionate response to bring a prosecution, since you are limiting somebody's freedom of expression. Do you think that's done very well, Ivan Hare?
Can I deal first with the point that Gavin made in relation to Mr. Hammond? He obviously wasn't prosecuted under the offence of incitement in relation to sexual orientation because that offence wasn't on the statute book at the time. But I'd question whether or not it would have been as easy for him, as Gavin suggests, to rely on the defence. Because what Mr. Hammond was saying was not only that you should stop homosexuality and stop lesbianism, but you should stop immorality. And therefore, arguably, he was criticising those people who are of that sexual orientation, not just the practice, and suggesting that they're immoral. And in those circumstances, I think it's at least arguable that he would have fallen within even the more narrow definition of incitement to hatred on the grounds of sexual orientation.
Surely he couldn't be seen as threatening. I mean, there has to be threatening words for the sexual orientation and the religious hatred, and I can't see how that is threatening. It may be insulting, it may make you feel sad, it may make you feel a bit cross, but I don't see that it's threatening you. Threatening you surely has to involve, I would think, saying that something bad should happen to you. I mean, the one case in which I think has been successfully prosecuted under this offence is a group of Muslims who are handing out leaflets saying that gay people should be executed or killed. And that's a clear threat. And I think, that falls plainly under the Act. And that, to me, is the kind of thing, albeit a clear-cut example of the kind of mischief you have to be inciting before you could get prosecuted.
It does seem slightly strange, though, by suggesting you should cut down on immorality and nothing much more than that. It sounds like an odd discussion in the country where we prided ourselves on free speech, because that seemed almost a bland thing to say. What about, I've got loads of these examples. Can I just quote a few examples to nudge the thing along? There's a guy called Philip Pritchard of Swansea, and he was prosecuted for using racially aggravated, threatening, insulting, abusive words and behaviour. He was singing anti-English rugby songs on a bus. And there's a Petra Mills found guilty of racially abusing her New Zealand-born neighbour, Chelsea O'Reilly, by calling her a stupid fat Australian. So grounds for criticism for being inaccurate, but...
I think there is a fundamental distinction, though, between abuse, which is what some of those examples might be, and the face-to-face abuse that Gavin was talking about earlier, and people trying to make a contribution to public debate or discussions on matters of public controversy. And whatever you might think about Mr. Hammond's views on homosexuality, there's no doubt that he was trying to express a view on matters of controversy, morality, sexuality, law reform.
Whereas rugby songs obviously don't form within that category.
Probably not. No.
What about saying to David Cameron, you've got blood on your hands? That's another case, which there were surrounding aspects of it, but you've got blood in your hands as a sort of thing could be said to almost any politician at any time in our history.
Well, and it has been, and it was often said about Tony Blair in relation to the Iraq War. And people often say, well, we're not really prohibiting very much speech because you can always rephrase the offensive speech that you've used in a way which wouldn't fall foul of the law. And the reason that people don't find that satisfactory is that distinction doesn't seem to accept the fact that people, A, need to use shorthand when they're communicating in public in a protest, on a banner or something like that, but also that people select the words they want to use for their emotional impact as well as for their intellectual content. And that can be just as important a part of what they're saying. And it leads into the whole debate there's been in America, which people are sometimes surprised about here, about protecting the US flag, which is regarded as a matter of immense importance to a lot of American citizens, so much so that it was proposed there should be a constitutional amendment so that it would be a criminal offence to burn the flag. And the court repeatedly said, no, of course there are less extreme ways and less offensive ways of expressing your opposition to the state, but this is a very effective way and it should be protected.
In fact, Section 5 is even worse than that, because
Gavin Phillipson.
The mischief with Section 5, with this use of the term insulting, which magistrates' courts have held as essentially a question of fact and therefore quite hard to review on appeal, is that, and this is what the Americans find particularly baffling about cases like Hammond, the preacher, is that what the court said was essentially he didn't use words like fags or insulting terms about gay people. It was actually the message, the content was seen itself to be an insult, which would therefore mean that in a sense the Bible, anytime anyone reads out the Bible, in a sense they potentially could be committing an offence depending if there's anyone listening who might be offended, which is getting a bit ridiculous. So in other words, it's not even that you can get out of it as Ivan was suggesting by using kind of more polite language. In fact, there doesn't seem to be a way under the Hammond case, in which you can express a Christian opposition to homosexuality without committing a Section 5 offence, which is something that's gone horribly wrong there.
Well, Section 5, and you've drawn attention to the word insulting, which has been the controversial word, and I think the position is that word has been removed or is going to be removed in a redrafting of the offence. Andrew Trotter, again, coming back to you as a policeman, did you find it useful to have insulting in these sort of crimes?
Not particularly, no. I mean, I quite welcome the move to remove insulting from this. I think it's one of those things that will take us away from some of the overzealous use of Section 5, get us back to focusing on its real use for us, which is much more around Friday night town centre policing and dealing with antisocial behaviour and protecting people, and less around but acting as the policing of people's views. And I find some of those examples that have been used so far very uncomfortable indeed.
Well, I suppose that one when I think it was called Sam Brown called a police horse gay. I don't know on what basis that was disputed, or whether they had to prove the horse was or wasn't gay, or whether it was insulting or abusive, or was it just the impatience of the officer, I suppose, more than anything else.
And who knows? I mean, none of us were there, and there may have been a little history before that. But nevertheless, this was clearly hard to defend. And of course, it was prosecuted. And you do ask the question, not only the first instance of the decision, not only by the officer, by the custody officer, and then the CPS, to say, why are we taking these things forward? Because there's enough for us to do without getting engaged in this sort of thing. And I think this is perhaps a really good opportunity for a good look at this and say, let's get back to what this is for. And it isn't for us to start policing people's political or views.
Well, I think it's the comedians were worried about this sort of definition, because there are insult jokes in comedy, and I suppose also in plays and all sorts of things. That was a worry for them, but of course that's no comfort to you if you're on the street and being insulted, I suppose.
It comes back to this distinction between face-to-face insults, which it's a perfectly legitimate thing for the police to deal with, and I don't think anyone who believes in a strong sense of free speech would object to that, and dealing with matters which are, even if crude contributions, attempts to make contributions to public discussions. And the other aspect that we haven't addressed yet in relation to incitement to hatred, which a lot of people find objectionable as a matter of principle, is that the incitement to hatred laws are actually based on the effect that the speech has on the audience, that is to say, the intended audience, the people you think are likely to agree with your position. So if you're addressing a group of fellow racists or other people who share a particular intolerance, your likelihood of being convicted of the offence is if your words are likely to have an impact on that audience. It's not directed at the minority or other group that's being attacked. And what a lot of people find so objectionable about that is that it seems to turn our protection of free speech and the reasons we protect free speech on their head. Because we normally think we protect free speech in order to encourage people to hear a range of views and then make decisions on important matters of public controversy. But what an incitement to hatred provision says is, we, the state, are going to stop you from hearing this message, partly because we're afraid that you might be persuaded by it. And we regard the views that someone is seeking to persuade you of as views that we disapprove of very strongly. That seems very paternalistic and fails to attach adequate importance to the autonomy of the audience.
So you think that we've gone too far already on this?
Yes, I think incitement to hatred, given the manner in which the offence is expressed, it can only be intended to prevent an individual from influencing another person to share their political views. However objectionable those political views are, it seems to me you have to let that play out in the field of competing ideas. And usually by exposing those kind of hateful ideas to discussion, you reveal how foolish they are.
And I take it, Neil Addison, you'd agree with that from what you've been saying so far?
Entirely, and I think John Stuart Mill, I think, was the one who said that if the whole world was of one opinion and only one person disagreed, the world would not be justified in silencing that one person and expressing their opinion. And there is the other basic point that good arguments, at the end of the day, drive out bad arguments. But if people feel that somebody is not being allowed to put forward their argument, they tend to attach much more credence to that. They tend to think there is something in that. There is something they don't want us to hear. And that adds, actually, more value to those who are inciting, who may be accused of inciting hatred.
Stokes up more problem. So what do you say to that, Gavin Phillipson? Do the John Stuart Mill argument, and these are robust traditional values of defend with my life your right to say it, that sort of thing?
I think many people think now that John Stuart Mill was hopelessly optimistic and thinking the truth would always win out. In the age of the mass media, where you have enormous corporations that can hugely inflate their message and drown out the speech of other people effectively in the so-called marketplace of ideas,
I don't think we can from hate crime or incitement to hatred, aren't we?
If you base your opposition to hate speech on the view that, as Neil said, that good arguments will drive out bad, I'm not convinced that's always the case. Why is there such a large the United States has got the freest speech in the world, and yet a large amounts of people in the United States believe quite balmy things. For example, there's an enormously high degree of belief that climate change is a load of witch doctor made up by left-wingers who want to steal your taxes, despite decades and decades of patient, scholarly speech by scientists trying to convince them, but it's drowned out by the right-wing chat show host. So I think John Stuart Mill had some nice ideas, but I think he was a little naive and optimistic in that one.
Well, I follow what you're saying there, but is that a justification for bringing in, restrictive laws relating to what people may say? Because you, and it may be you'll have people agreeing with you, maybe you're not, you don't think that people have got it right on climate change or a range of other things.
That was just an example to show.
I know, but you're I suppose you're revealing your position on the thing affects your attitude to the conclusion that other people happen to have got so far.
The only hate speech bans that I would support in relation to speech that's put in that is sort of intended to be a contribution to public debate, so not face-to-face speech, but speech published on blogs or a speaker like Hammond, making a speech in a public place, would be that which tried to deny the humanity of people or incite violence against them. So I would support only very, very narrow bans. And I actually think we have some duties as members of the democracy, not just rights. And I think if we participate in democracy and if we claim human rights, which are based upon the idea that we all have some essentially shared humanity that makes us equal in a way and therefore gives us the same rights. That's the idea of human rights. I think it's an abuse of those rights to try and convince other people that certain people are less than human or that they don't deserve to be treated as citizens. So in America, that is, in fact, that's permitted. It's called content neutrality. The state can't restrict a message just because it disapproves of it. It has to be said that nowhere else but America does that, and every other democracy has found it necessary that some viewpoints are so dangerous or so inimical to democratic society that they can legitimately be, at least the state can express its authoritative disapproval of them by making them offences.
Closer to home, Andrew Trotter, as a policeman, you have to deal now with football crowds, that what they can shout at each other is covered by this legislation and specific legislation. Do you think that's a useful tool in your locker, or is it an extension into policing things that might be better left alone?
Well, we'd be extremely busy if we dealt with every one of these that cropped up at a football match. And there is a context to this. That a lot of the chants at football are directed at players or referees are, without doubt offensive, which are accepted as part of, unfortunately, the British football culture. When they get on a train or in the high street afterwards, that might be different.
Yes.
But there are things that they do. When you start to think about whether it be in Liverpool making comments about Hillsborough victims, whether it be comments made at Tottenham about the Holocaust. I mean, you start to think, well, where do we go on this continuum of abuse, and where do we think we should step in? And this is grossly offensive or likely to cause a reaction and a violent reaction. And there is common sense doesn't normally crop up when we have these dry legal discussions, but there is something about discretion and common sense and context that I would expect to be exercised with sometimes rather more care than perhaps we have done so hitherto. But there is a role, I think, for us to step in where appropriate on the extreme end of these comments and actions in order to protect people. And it is around, I think, a duty. If people give up the right to retaliate against offence, if they give up the right to defend themselves physically, then the state has a duty to protect those people. I think the key for us is to ensure that we don't step in unnecessarily, that we use good judgment, sound judgment, use the Human Rights Act as a good measure of a requirement for a proportionate response, and not thinking we have to investigate every allegation, which I think is a common mistake among some colleagues. They think they must investigate because someone has made that allegation.
Yeah. Well, in Manchester, apparently they're even recording attacks on goths, emos, punks and other types of youth culture as hate crimes. I mean, almost literally fashion police you're going in there to deal with. Now, that again is extending the categories of people who can be seen as needing protection, because if you're attacked because you're a goth, you're as attacked as much as if you're gay or of a particular race.
Yes, and the outcome from classifying that doesn't make an awful lot of difference, to be frank. You're still being attacked. The fact that they may classify it in some way is interesting, but the practical import of saying that is not very much, because whether you're a goth or whatever you might be, you're entitled to be protected from violent assault. I think what it was much more of a demonstration to that community and that group that we do care about them, and any previous perhaps antagonisms or antipathy from the police in the past has gone by, and we're much more sensitive to their concerns, because funnily enough they do get a lot of attacks just for the way they dress.
Neil Addison, did you deal with that sort of thing when you were a senior Crown prosecutor, different groups being attacked?
Yes, and I mean, if the police are just doing it from a statistical point of view, they want to find out whether particular groups are more prone to attack, then I've got no particular problems with that. The problems are when you start getting aggravated offences. So, for example, in Liverpool, if a Liverpudlian hits a Geordie, that's ordinary assault, liable 6 months imprisonment. If they hit somebody from Scotland, then that's racially aggravated assault, imprisonment 2 years. What's the difference? Both people have been assaulted. The law should deal with both crimes equally.
Sure. They might get a headbutt first as well.
It's not quite correct.
Well, no, that's it. You see, isn't that a prejudice remark?
It's not correct.
And potentially an insulting and hate crime.
Neil, it's not correct to say...
but that's the problem, isn't it?
No one attacks me without being responded to.
It's not correct to say that they would get 2 years just because the person was Scottish. It would have to be shown that the motive was, hatred of Scottish people.
Yeah, come on.
You suggested that...
If you hit a Geordie because he's a Geordie, or they hit a Scotsman because he's a Scotsman, there's a difference in the penalty, and there is no logical reason for that.
I suppose all laws butt up against this occasion as to finding where one thing ends and another one begins.
Hate crime
but there was a prime
issue.
example just earlier when somebody was talking about climate change, a load of rubbish, or the point of view that it's a load of rubbish shouldn't be allowed.
No,
I might feel insulted by that, because I think the whole science of climate change is a load of rubbish. Surely my incorrect views should be expressed without interruption, just as your incorrect views should be expressed without interruption. And then society decides which views they wish to follow.
No one was suggesting otherwise. I was merely trying to refute the view that the truth will always win out in the end, which I think is optimistic. That's all.
I think you
no,
fell foul
but that's the point. You see, you decided what the truth was, and then said, what I decide is the truth isn't winning out all the time.
I think it's a fair point, but it's been made already. I want to in the time available, deal with social media and Twitter, as we've mentioned it in passing, because there are plenty of examples who have hit the headlines. For example, Paul Chambers got cross because Robin Hood Airport was closed again, and he acquired, until he won on appeal, a conviction for sending a menacing electronic communication because he said if they didn't get their act sorted out, he was going to blow it up. Now, I suppose that's another... I have to go back to you, Andrew Trotter, as a policeman, because the odd thing about that is it seems to have been clearly identified as just a joke quite early on. But that didn't stop the police taking action, the Crown Prosecution Service, the CPS taking action, and the court at first instance convicting and imposing a penalty.
I find it completely inexplicable. All the way through, people seem to recognise this wasn't terribly real, and yet it still had a life of its own, and I do find it quite extraordinary. It should have stopped at the first instance. It should never have got past the police. It should never have gone to the CPS, and the CPS shouldn't have run it either. It is really difficult to understand when you look at that case again how it got us into this particular position, and I just think, I don't think anyone could defend what happened there.
But Ivan Hare, should people be bearing in mind what they're putting on Twitter could be investigated and looked at? We've mentioned a couple of examples along the way there. There's another one where people posting particularly unpleasant messages about Tom Daley and his father, and that was investigated. I don't think any prosecution was brought there, but are we allowed free speech, or are we limiting free speech so you can't say things which are stupid or which are just unpleasant when they have no other effect other than that to be part of the soup of things that everyone might choose to read or not?
Well, I think you have to accept that people use different means to communicate their messages now than was the case in the past, and that people will use social media in order to contribute towards the kind of public discussions on matters of general importance that we've been saying it's so important should be defended. And I don't think there should be different principles applied in relation to those kind of discussions. But again, one draws the distinction between that and singling out an individual for a particular form of abuse, to which different considerations may arise. arise. But the further difficulty, I think, is that essentially it seems that a legal regime that was intended to govern broadcasting and in particular to restrict the broadcasting of offensive material, which was understood to mean material of a sexual nature or swearing and so on, is simply being applied to other forms of media which aren't really broadcasting in the same sense as those for which, say, the Communications Act or previously the Broadcasting Act were passed to resolve. And the difficulty with having these other offences on the statute book about incitement to hatred or the Section 5 of the Public Order Act that we've been talking about is that they then define the scope of communication in these new areas, and electronic medias too.
I'm afraid we're coming to the end of the programme, so I wonder if I can ask you to pull all this together, or each of you. Is there a way where you could improve the law in one go? Start with you, since you're a professor, Gavin Phillipson.
I would actually leave the religious hatred and sexual orientation hatred statutes on the statute book because they're very, very tightly drafted and they should allow for a full range of free speech. I would remove Section 5 or certainly do the reform that's been done. We shouldn't have the police essentially being able to kind of censor political messages on the street, and I would get rid of the provisions in the Malicious Communications Act that prohibit grossly offensive content on Twitter because it's just far too uncertain and too subjective.
Do you think there needs to be some clarity in the law, or are you happy to leave it to the police officers and the prosecuting authorities to define or discern the context?
I think they've been given incredibly uncertain laws that contain words like grossly offensive that no one really knows what that means, and different people find different things grossly offensive and ask to try and make sense of them, and it's no wonder that they make mistakes sometimes because they're being given an impossible job.
Andrew Trotter, you've been given the impossible job, so I'll give you another one. How would you rearrange the law to make it easier for you, but in particular easier to make it better for the citizenry?
I think I take the example of the Director of Public Prosecutions' interim guidance on social media has been really useful. I mean, there are still some areas of concern, without a doubt. But I think that sort of approach of a high threshold, clear public interest, I think can be applicable beyond social media into things like Section 5, without losing its real use to us, as I say, as a Friday night tool to deal with disorder in the streets. But I just do not think we should be into these other arenas at all. It's not for us to be policing political views. It's not for us to take up cudgels on behalf of people who are feeling offended. It is only for us to deal with where there's a real issue, where people are being victimised, harassed, threatened, and in those much more extreme areas. And I think it's sort of giving clear guidance to police forces to apply very, very high thresholds to these things before we even start looking at them.
Neil Addison, do you agree with that, or would you go even further?
I would get rid of the racial, religion, sexual orientation, incitement laws completely. I'd get rid of the aggravated offences completely so that the law is equal to all. And as far as the Communications Act, I would say messages directed at another so that we are protecting individuals if they receive grossly offensive messages, but we're not having policing just because somebody has said something on Twitter generally which other people then take offence to.
So you're cutting a scythe through an awful lot of recent legislation then to get rid of these particular offences.
I would get rid of most of it.
I wonder if you've got any support from our last contributor, Ivan Hare. Would you take a scythe as well, or are you happy to leave a few standing?
No, I'd certainly agree that we should abolish Section 5 and that we should, and I would agree with Neil that we should repeal the incitement to hatred provisions. Where I disagree with him is in relation to hate crimes. I think you can properly draw a distinction between the situation where someone's crossed the line and committed a criminal offence, usually one of violence, and selected their victim on the grounds of one of their protected characteristics, that it is legitimate to punish that more seriously. And I don't think one can seriously argue that there's any communicative content that you're there restricting the distribution of.
All right, well, there we've illustrated the problem with free speech. We've got 4 experts, and you've all given 4 completely different views as to how to reform the situation. I'm afraid that's all the time we've got for today. Speech may or may not be free, but we must stop speaking now. My thanks to all my guests, Professor Gavin Phillipson, Ivan Hare, Neil Addison and Andrew Trotter. I'm Clive Anderson. Next week we'll be discussing secrecy in court. Until then, goodbye.
Unreliable Evidence is produced by Brian King. It's an above-the-title production for BBC Radio 4, and you can find out more about the programme on the Radio 4 website.